My name's Rick Ballou. I have been part of Open Oakland for going on 6 years now. Some of us have been around that whole time. I want to first report to you that about 4 of you said you had filed public record requests, FOIA requests, or CPS, California Public Records Act requests, according to the Meetup questionnaire. How many of you happen to have ever filed one of those before? How many of you are journalists? Do any of you consider yourself journalists? Okay. How many of you are city staff? Great. I want to use this opportunity to thank city staff especially. It's a Saturday. It's on top of their day job. Open Oakland does not work unless we have traction inside City Hall. And when we do have a conversation going, magic occurs. So I want to thank again all city staff, Suzanne Duran in particular from the Public Ethics Commission, Mylene Garcia, who's not here. We saved you a seat. Hi, Oliver Looby. So, take a minute to appreciate that on a Saturday afternoon, this many people are interested in such a nerdy, geeky topic as public record requests. That's kind of amazing all by itself. Before we get really going, I want to just do a wave at some ground rules. So first of all, there's a color code we've adopted around photography of people in this session. And blue means it's fine to take your picture. Red means no thank you. So if any of you are taking pictures or live tweeting or any of that stuff you kids do, please respect those rules. I'm proposing OhCPRR as a hashtag. If you want to do any of this and be pulled together, go ahead. City staff are appearing as a courtesy, and there are constraints on what they can say in their capacity as city staff. So in particular, Tricia will not be able to take questions from the audience during the question and answer period just because it might be conceived as legal advice or a legal opinion, and that's just not something that can happen. So just a word of pre-warning. Code of conduct is also something that Open Oakland takes real seriously. If you go to the website, openoakland.org, you'll see a fairly long statement of a lot of them. I've pulled just some of the features that I think are especially relevant here. Presume the values of others. Differing ideas, skills, contributions all play a crucial role. Encourage members and participants to listen as much as they speak. Consider access for and input from those who are traditionally excluded from the civic process. Create and maintain positive relationships with community partners, community members, and local government staff. Actively involve them in decision-making process. That's what we're here to do today. Oakland Sunshine. If you visualize Oakland Sunshine, I'm thinking like Thursday, which was the last time it broke through the clouds. But in fact, Oakland Sunshine was the name of a publication, 1897 to 1923, helping you appreciate what an old city we're in. And its editor was John Wilds, who was the long-term janitor in City Hall. Can't you imagine some pretty interesting stuff got published in that paper because of his role within city government? So, first thing to learn about Oakland Sunshine. But really the kind of sunshine we mostly are thinking about on a day like today is Louis Brandeis's notion of a disinfectant that helps to clear the air. Another little factoid I learned was even 20 years before the famous phrase, he was saying things like, if the broad light of day could be let in upon men's actions, it would purify them. This was part of an essay that was the flip side of a privacy essay he wrote. So the issues that we're talking about go back that far. When I think about why it's worth doing an event like this, it's because I see public record acts as a dynamic process revealing data that the city and progressive government tries to provide to its citizens. So for me, the goal is something like the Socrata interface at data.oaklandnet.com. I'm using the old URL there because the new one doesn't work. oaklandca.gov does not take you to this. Just a little note. The goal is, I would say, public record requests are an indication to government agencies of interest by their citizens. And if they get tens and hundreds of these, then it's going to wind up being easier to just put this data out there where people can see it. That's the dynamic I'm talking about. This happens to be Oakland Police Department data that will figure in just a minute on another slide. Context for today. So first of all, we're part of a Code for America organization, a nationwide group that has brigades everywhere. And while I'm talking about the national organization, I want to mention that they're having their national meeting here in Oakland, May 29th through 31st. Put that on your calendars. It's going to have a really interesting set of speakers, including old folks like me. Bruce Schneier is one of the old security people from back in the day, long time ago. It's also going to have Alex Stamos. Do any of you know that name? Yes. So he was the security chief at Facebook and had done many interesting security-related things before that. He then loudly left Facebook, calling it things like Game of Thrones. That leadership within Facebook reminded him of Game of Thrones. And now, he was a UC Berkeley grad, and now he's at the Hoover Institute on Stanford campus. So he's going to have interesting things to say. Open Oakland. I want to just kind of sing about Open Oakland because it's grown so much over the time I've been involved. This picture helps to capture it, so Colin and Ellison in particular, I want to thank for help today and show off their new swag, so you didn't even have to wear it, Colin. You're recorded. Also in the picture is Tom Dooner, who was roughly lead of the group last year and has done a great job last year and helping us this year as well. If there's one thing great leaders do is they lead great leaders to pick up the reins behind them, and Tom's done a great job at that. It's a networking opportunity on Tuesdays, 6:30 to 9 every week. It's done things like open budget and open disclosure that some of you may have heard of, and they're active projects in and of themselves. Another piece of context is that Record Track was a Code for America Fellows project back in 2012, 2013. It went live for the city of Oakland in 2013. And if this works right, I'm going to be able to do this. And okay, it's not going to do that, so no problem. You would have seen this. This is something Reed's going to be talking about more, but it's a system for searching through prior public record requests, a repository of prior experiences that you can benefit from. Terrifically useful system. All that's part of the context. Once you start looking into this issue of public record requests, you find all sorts of things. Some of them humorous. I think this wins for my humor that the city of Detroit produced a lookup table of its absentee precincts where they had put clip art in all of the cells. So you can see how sometimes it might seem like there's an adversarial relationship between giving information and asking for information. This is also great. The boxes are stacked in such a manner, causing it to be dangerous for an employee to enter the container to retrieve the records. Okay, so this is one part of our background. Here's another part, getting a little more statistical. And this I got at Freddie's talk 2 weeks ago. He mentioned I ran it down, Columbia Journalism Review. How many of you would have guessed the small fraction that news media play of FOIA requests? The bulk of, yeah, okay, yeah, see, we have professionals. The kind of reconnaissance that lawyers and private corporations are doing dominate by far what news media, nonprofits, and others are doing. That's a pretty interesting factoid. Let me bring it a little bit more locally. If you look at PRRs for Oakland from October 2013 to March 2018, you get a distribution across departments that looks like this. 2/3 of them are to the police department. That's the bulk of requests that Oakland's needing to handle. They come in at something like 500 requests a month. This data is useful and relevant up until about March of 2018. The API that was provided for RecordTrack allowed this analysis and is no longer available. So this is one of the things up in the air. Here's an example of how public record requests have been useful as part of the crime project. OhCrime, let's try this again. Maybe our network connection is better. OhCrime takes data from the Oakland Police Department and makes it available to Oakland citizens as a map and in other ways for visualization. That data comes primarily from that API access that I mentioned earlier, a daily harvest from that source. However, if you look at certain public record requests, this one's RT 6313 from October 2014, they made a request that was satisfied with a spreadsheet. That spreadsheet has two particular columns, the statute and UCR code, that's not part of the standard interface. But because there's unique identifiers and also time and date stamps, addresses and time date stamps, we can match them. That means we get a critical bit of information, the actual statute under which an incident falls, that wouldn't be available. This is the kind of dynamic I'm talking about. It's data that's important to groups of citizens, and PRRs are a mechanism of getting that. There's lots of other ones. This is not a unique example, these spreadsheets attached to public record requests. Here's another somewhat troubling recent trend. Several of these responses now read, responsive results sent to the requester's email address, as opposed to being attached to the next request record, as I thought they're supposed to be. The whole point of this is that we can benefit from one another's queries. So, I'm laying about a bunch of stuff out. We have a short period of time to discuss it. hopefully we're going to get at the end of this and have ideas about next parts of the conversation. We're going to have 6 speakers, 10 minutes each. I'm going to try and keep you all pretty much to that. Then we're going to break for questions, and Tricia is going to absent herself from that part. And then we get to have snacks. And then the kind of conceit is, wouldn't it be fun to try and draft some public record requests and see if we can learn something about how to do that better? Some of us in Open Oakland have tried to do this before. That was really the point of having this event in the first place. How can we draft well-stated requests? We'll get back, we'll look at them, come up with whatever conclusions we can, and then call it a day. So here's an example of a public record request, just so you get a sense of a real one that I would really be interested in, and that is namely, please give us the statute penal code and UCR code for all of the incidents that you've given us the other data about, please. We have terrific panelists that have agreed to join us today. I'm really grateful. A broad range of perspectives. We're going to walk through them in this order. Michael Risher, who's been practicing in this area for how many years? I don't know. You can tell us. Oliver Looby, who is one of the few people I've known before today out of Dan Kalb's office. James Jacobs, someone I just met a couple of weeks ago around a similar event in San Francisco, who has, turns out, know a lot about sort of the archival side of this question. Tricia Hayes from the City Attorney's Office. Reed Ducey-Gibbs from Next Request, the company who is providing the software that I showed you in passing. And Jill Butler, who's from the Public Ethics Commission. So without further ado, I give you Michael. Mm-hmm. Do you want to use your machine? I don't have them on mine. You gave them to him.
Right.
So you can either send them to me, or I can, if you've got HDMI, I can just plug you right in.
Yep, I got a mini plug.
Okay. Do you have his? Oh, here, you've got it on a USB, right? Yes. So why don't you say what you can, and I'll...
Okay. The slides aren't all important. So my name is Michael Risher. I am a lawyer. I now specialize in open government laws. I was with the ACLU for the last 12 years, where I did most of our California Public Records Act, California Public Records Act litigation, and helped people draft requests, and gave advice on that, and gave a bunch of talks like this before. So I am primarily going to talk about the California Public Records Act and how to draft a good request, and some of the law in that area. I don't actually know what's going to be most useful for people. I am happy if people have questions they want to ask me or specific stuff, but why don't I just charge ahead and we'll get there. So, you can't see this, but I can. We have a number of open records laws in California. We have the Public Records Act, that's the primary one. We have a bunch of local sunshine ordinances. Oakland has a sunshine ordinance, and I take it somebody here is going to talk about that. Yes. So I'm not going to talk about the Oakland Sunshine Ordinance. We also have special open government laws that apply to the legislature and to the courts. The legislature is not covered by the Public Records Act. Funny how they created a law to affect everybody else, but not themselves. There is, however, the Legislative Open Records Act. It's kind of similar to the Public Records Act. The courts are covered by a rule of court 10.500 if you care, and also the First Amendment provides us a right of access to court records. So if you're trying to get records from the legislature or from the court, you need to follow the procedures in those laws. I'm not going to talk about them today much. We're mostly talking about local government, Oakland specifically, which is covered by the California Public Records Act. Every part of the government is, every part of the Oakland government is, with no exceptions. I've got 10 minutes, so I'm going to focus more on what I heard is going to be useful, which is how to make a good request, rather than the specifics of what you are entitled to receive. Because the reality is that there are a lot of exemptions under the Public Records Act that exist. However, government officials can still give you the vast majority of information that they don't have to. There are a few areas, peace officer personnel records, things that are privileged, where they can't give you the stuff even if they want to. But for most exemptions under the California Public Records Act, if the government wants to give you some records that they don't have to, they can. It's up to them. Yeah?
Jump to this one?
Sure. So my strategy in making Public Records Act requests is to make them reasonable, realize that the person who is dealing with
You know how to
those...
drive now?
Thank you. I can see it. Is to make them reasonable, realize that the person who's dealing with Public Records Act requests in whatever government agency you're dealing with, that's probably not their only job. They've probably got a lot of other things that they need to be doing, and if you can make their lives easier, then you're more likely to get what you want in a timely way and with a minimum of fuss. If you jump in and you try to make their lives difficult, as some people do, particularly lawyers, you're shooting yourself in the foot, or use some other metaphor, because nobody wants to help a jerk, and why do that? Be polite, be respectful of the person's time. You're much more likely to get what you want, and of course it's the right thing to do. So, in a Public Records Act request, you need to request records. If you request information, most government officials are reasonably going to say, okay, this person wants information, here's what the records that contain that information. But they don't necessarily have to. So when I make a records request, I say, dear so-and-so, please send me records containing the following information. If you know the name of the record and you want, whatever, minutes from city council meeting that happened on January 1st, 2019, probably not a council meeting that day, go ahead and ask for it. But the law recognizes that we don't necessarily know what we want. If I want information about crimes that happened on my block, I don't necessarily know the name of the report, the name of the database, the name of the document or record that contains that information. So I'm allowed to say, hey, please send me all information you have about crimes that occurred on such and such block on such and such date. And you can be more specific if you want. You don't have to. My rule of thumb is you should ask for what you want, whether or not you think it might be exempt, because as I said, they can give it to you even if it is. But don't try the trick that some people try of, well, if I just ask for what I want, they're going to get suspicious and they're going to not give it to me because they don't want to give me what I want. And so I'm going to ask for everything in the world, and then buried in that will be this little nugget of what I want, and that's going to be great. That's not going to be great. You're going to make the person unhappy. You're wasting their time. You're wasting tax dollars, your own tax dollars, and you're not going to get that stuff because they're not going to have the time to look for all of these records that you don't really want and the records that you do really want. Or if they do, it's going to take forever for them to do that. So, 3 minutes. Ask for what you want. Describe it as accurately as you can. Don't go overboard and ask for a bunch of other stuff. As you can see up here, it never hurts to ask for more than they have to give you. Ask for entire documents if you want entire documents. And figure out where to send it. That can be an important thing in the Public Records Act world. If you send it to the wrong department, Maybe legally they have a duty to forward it to the right department quickly, but that doesn't always happen. Again, use their website, use the phone, figure out where to send it. This is all self-explanatory, and I just said it. This is in the materials you're able to look at. It's a Public Records Act kind of shell that I've handed out for a gazillion years. Here's a Public Records Act that I did a long time ago at this point. It's also in the materials. It just shows the type of thing that you might do. This was a pretty detailed request to the Department of Corrections for information related to the death penalty. I send Public Records Act requests. I sent one in an email last week. Hey, I noticed the link on your website to this document's broken. Please either send me the document or update the link. And the response was, here's the document, and thank you for pointing out that the link is broken. That took an hour to get that. Check for local sunshine laws. You already know that. Just a couple quick things. They have 10 days to send your response. The response doesn't mean the record. The response means they've looked at your request, they figured out whether they have responsive records, and that they're going to give you, period. In unusual circumstances, which are kind of broadly defined, it can be a real big request. As I said, don't make your request too big. It can be because they have to consult with some other agency. They can extend their time to respond for up to 14 days. After they decide whether to send you records, if they have records to disclose, they got to send them to you promptly. 1 minute? That's not sit down and do that? Okay. Don't start calling them up on day 11. Where's my response? I always give them a few extra days. Sometimes, for whatever reason, agencies want to send this stuff in the mail, and it takes a while to get to you. After a couple weeks, call them up, figure out what happened. They do lose these things. Sometimes it's not in good faith. Usually it is. It gets misplaced. It gets sent to the wrong place. Call them up, say, hey, I sent this, or send them another copy. Hey, what's the deal? Usually that resolves things. Sometimes you have to pay for copies before they'll even mail it. That's a drag. I always say, look, send the stuff and I'll pay you later. Some agencies do that, some don't. Copy costs should not be more than about 10 cents a page. We're not going to get into all of the rules for electronic documents and what they can charge for. As I said, once they make the determination, they have to give you the stuff promptly, and I will promptly sit down. If you have questions, I'm happy to answer them in the right time.
Next, thank you, Michael. Oliver, you're up next, and you don't have slides.
No slides.
There's a bunch more in my slides about what you can do in the PRA, so no need to go.
Good. Is that close enough? Okay, thanks, Rick and Open Oakland for having this event, inviting me. My apologies for being a little bit late. I'm Oliver Looby. I'm the Chief of Staff for Councilmember Dan Kolb's office, where I've been for a number of years. And a little bit about my background. I've had the privilege of both being able to respond to numerous records requests, as well as being able to make numerous records requests as a private citizen across many years. Prior to working for the City of Oakland, working for Dan Kolb, I actually worked in the City and County of San Francisco for the Ethics Commission there in a very different capacity. And I've responded to records requests in both jurisdictions, as well as a private citizen, made records requests in both jurisdictions. And so I feel like that helps give me a pretty unique perspective for both sides of the aisle. In fact, a little detour to show you how near and dear public records requests and Sunshine are to my heart. In 2004, me and another employee at the Ethics Commission received a record from a law firm. It was sent to the wrong Kevin, and it was an accounts payable and receivable record for a political candidate, an actual office holder, showing money laundering, which our boss at the Ethics Commission at the time ordered us to destroy. And so we preserved the record and ended up getting into a big fight with the boss and filing a complaint with the Sunshine Ordinance Task Force in San Francisco about this. Long story short, we were vindicated by the task force and the press. Kevin was let go. I eventually got run out of the office there as well. But the press and the advocate community stood by us, and it showed the power of these local disclosure laws in terms of protecting the public's right to know. with the current system, I was involved a little bit with the Code for America Fellows that developed the record track system back in 2013, 2014, which is now Next Request. And I know you're going to be hearing more from other speakers about this, but in my mind, the three main purposes of a system like this are: one, to facilitate the making of the requests; two, to facilitate the government's ability to respond to the requests; and third, and very importantly, meta-disclosure. Meta-disclosure is a concept that I became familiar with back in my San Francisco days. There was a group, how many people have heard of the Sunshine Posse, San Francisco Sunshine Posse? Maybe it's kind of obscure. There was a ragtag group of advocates and FOIA warriors in San Francisco who in the aughts got the idea of auditing. Back then, all responses by the city and county were done either via mail or hard copy or email. And there was no centralized system for the disclosure of these kinds of requests. And so they took it upon themselves to audit, effectively as members of the public, audit the responses to records requests by not only requesting all records requests that have been submitted to various departments, but also the responses to those requests, and then posting them all online and comparing them across department and across request. Hence, that was meta-disclosure, and it showed that there was inconsistency sometimes in the timing of the response, what was disclosed, which departments were responding, and so forth. And so when I met with the Code for America Fellows back in 2013-ish, that was one of the things I said you really have to have is meta-disclosure. And fast forward until now, we have pretty robust meta-disclosure with both Next Request and with Record Track before. And that is one of the features that I just highly recommend to anybody who listen that has to be preserved. Rick got into this a little bit when you saw the post of the documents have been emailed to the requester. There should not be that occurring in most situations. The records should be online so that both for the purpose of showing the public what the person was given, as well as reducing the need to make additional requests for that very same data. So the meta-disclosure is really important. On that topic, it's kind of shifting gears, and this might be a little bit controversial. I'm not aware of any government agency in the state of California that's adequately staffed to respond to all the records requests that they get. For my office personally, it's a backbreaking chore, and I'm super pro disclosure of records, and it is just a backbreaking chore. We just receive far more requests than we could possibly handle. The obvious, easy argument for responding to that is to staff up departments across the state so that they can adequately respond to requests. And the response that you get in Sacramento is these bills that come out every couple of years saying, well, the California Public Records Act is too broad, needs to be narrowed, which is obviously not the right path. My thought, and what I would encourage folks to start thinking about, even if it's way down the line that we could possibly implement this, is that we have a 20th century law that's colliding with 21st century data collection. And so the solution to that going forward, in my mind, is that the CPRA and various other sunshine ordinances need to be modernized at some point to require proactive disclosure of the vast majority of government records that we have. Put them in an online, robust database, and just put all the records you can out there before they're requested, so that the time that you need for a staff person to actually look at and develop the response to a request is reduced. At the pace that we're going at, it's becoming unsustainable. Eventually records requests will be automated by companies and law firms and as such, and it just becomes an unsustainable project to have this method of discrete requests that are responded to individually by a staff person. You have to get into the mode of proactive disclosure, even if that's going to require a tremendous amount of brain power and money statewide to implement. And that's my thoughts on where we're headed. Last but not least, is a little bit of a segue away from records requests. I was delighted to see that in the historical documents for this project, there was a post to a 2015 East Bay Express article about some budget priorities that Dan Kalba tried to get into they're called policy directives into the 15-17 budget that were rejected at the time from the budget. We actually, in fact, got them into the 17-19 budget, and I don't believe they've been acted upon, but this may be of interest to folks because it sort of dovetails with the idea of more transparency. One was that the Legistar system, which is the City of Oakland's system for providing all its legislative records, that the documents be made machine readable and searchable. At present, you can only search the title of these records, and I think maybe one other field. There's also a categorization by information report, legislation, and so forth. You can search that too. You cannot search the contents of any of the documents that are posted, and some of these are hundreds of pages and a treasure trove of information, including historical information for people doing research. We got to segue into making this machine readable and searchable, and this got started after that was put into this budget policy directive that was passed in 2017, and I honestly don't know what happened to it. I know there was an effort by the city to have a cross-department effort to make this happen, and for whatever reason, it hasn't. I don't believe it's manifested, even though it was supposed to be effective by April 2018. The other thing, and this is a little bit off topic also, but which was in this, was to have paperless agenda distribution and online archiving for meetings, for government meetings. Right now, it's sort of a balkanized system where you have different forms of both online archiving of government meeting documents as well as agenda distribution. In fact, some agencies still distribute their agendas in hard copy. And I'll spare, I won't name names, but there are agencies like the Public Ethics Commission which are really great on having electronic distribution of their agendas, complete archiving of all of their agenda materials by agenda item and so forth. Obviously, the City Council also has a robust system for that. But not every single board or commission within the City of Oakland has that same standardized process. And it's now it's a policy directive that was adopted in the 17-19 budget by the City Council to make that system paperless by default, and then also permanently archived online. So we have a ways to go. Bear with us, but groups like this encouraging us to do the right thing, encouraging us to be more transparent is what will get us there. So, and I'm happy to answer questions about any of this now or later.
I think I'm going to push all the questions to the end just for reason of time.
Sounds good.
Thank you very much, Alderman. James is back on here. Oliver mentioned something that I wanted to mention to you all as well, namely a resource page that we've started to put together with links to a lot of related materials. Signal. Well, that's curious. That's still on. This is still on. All right, well. It's not recognizing the second. Got one more try. Okay. Murphy is here in the house. We'll have your slides that people can see later. I'm sorry that we're not able to.
Do you want me to try my laptop?
We can try that, but you'll project to what? We don't have HDMI. I mean, you don't have HDMI on your machine, right? The dongle you have is VGA. Oh, no, you do have HDMI. Yeah. Okay, that's. Tech.
Always have a backup.
Yay. Okay.
Hi, everyone. So I'm James Jacobs. I'm the Federal Government Information Librarian and Federal Depository Library Program Coordinator at Stanford University. Is that good? For those of you who don't know, the FDLP is a nationwide network of approximately 1,100 libraries that have been working together since 1813 to help their local communities access and use government information, publicly available government information. And that means that anyone can walk into any FDLP library and use that institution's collections and services. Even if that institution is a private institution like my own, or Yale, or Harvard, or NYU, even UC Berkeley, you can go in, say, I need to use the government documents collection, and they are legally required to let you in the door. So it's a nice and it's a little known but valuable hack of libraries. So I recommend that everyone use that hack if you can. So while my policy and library work is primarily at the federal level, I think the Federal Act provides a baseline policy structure for what's happening at the state and the local level. And local initiatives that expand FOIA can and do bubble back up to the federal level. At least I hope that they do, especially through conversations like we're having today. And so thanks, Rick, and thanks Open Oakland for hosting and having this important discussion. With that said, I'll talk briefly about the Federal FOIA Act. And then I'll also talk about the role of the National Archives and Records Administration, that's NARA, and NARA's FOIA Advisory Committee, on which I'm a member, and what that committee does in terms of FOIA policy work. And then lastly, I'll talk about FOIA repositories and why they're important. So we charge our governments with doing all kinds of ostensibly public goods, from filling potholes to running our educational systems to policing, regulating the environment, the economy, national security, et cetera. FOIA is a law that gives any person or organization the right to access records of any federal executive branch agency upon request. It's a vital investigative tool for exposing government and corporate wrongdoing. President Lyndon Johnson signed the first FOIA law, FOIA Act, into law in 1966, and it went into effect in 1967. Interestingly, Bill Moyers, who was then President Johnson's press secretary, said that Johnson signed the law kicking and screaming. He hated the FOIA law because he didn't want journalists to be able to crawl through the government's closets to find embarrassing tidbits. So luckily, other people got Johnson to see the positive nature of FOIA, and he signed it into law. So I'm going to skip that one. FOIA is an important tool, as I said, for academics and researchers, journalists, lawyers, businesses, and the public. Interestingly, and I think someone else mentioned this, businesses and lawyers are by far the most prolific FOIA requesters, according to this article that Rick cited earlier. You'll see that, I don't know if you can see that, but later when you look at the slides, 39% of federal FOIA requests are done by businesses. So it should give you a pause to think about why that is, why business is interested in applying FOIA. So FOIA, as I said, applies to agencies within the executive branch of the federal government, not to Congress and not to the judiciary, and also, interestingly, not to contractors who are working to do government's business. So private contractors are not part of the covered under FOIA. So FOIA only covers about 1/3 of the federal government, but that's still a large swath of information that's available through FOIA. approximately 440 executive branch agencies and commissions that are covered under FOIA. There are, I think this slide here, there are 9 exemptions to the FOIA Act, including things like national security and personal privacy, even things like geological information of wells are not covered under FOIA. But for most people, they think that FOIA gives you access to everything. But I think when you look at what's covered under FOIA, at the executive branch, only about 1% to 3% of federal records are actually preserved in any sort of substantive way. And so many records created by executive branch agencies are only held until their due diligence is not needed anymore. So it's a very small swath of what's happening. As someone else actually said, the problem we're facing with the government agencies is that they're not really organized with FOIA in mind and are generally woefully understaffed and technologically ill-equipped to handle the vast number of requests that they get. And 3 minutes, okay. I'll switch to here. Most importantly, when we're talking about FOIA, we're mostly thinking about access to records. But Ralph Nader pointed out that there are actually 3 questions that we need to think about and need to be answered. And those 3 questions are, what do governments collect? What information is published? And how do citizens obtain their records? I think I'll skip through the advisory committee. Just so you know, NARA, the National Records and Archives Administration, created this committee to give it a way to support better FOIA law without having to go through the arduous legislative process. And I'm working on this committee. It's been going since 2014, and I can answer more questions about that later. FOIA repositories are super important. I'm putting my librarian hat back on. Most times when you think about FOIA, you end at the request, and you don't go forward with that. But I think it's absolutely important to provide long-term access to documents, and the documents that do get FOIA'd need to be collected, described, and preserved so that the public knows what's been requested already. I'm glad to hear that the local Public Records Act system is going to do something to that effect. But it also helps those agencies because if they release their records, they won't have to keep doing those FOIA requests. Repositories are made more feasible with the advent of online FOIA tools like MuckRock and FOIA Machine. These are really interesting tools. You can Google them. These online services help the public and help FOIA requesters organize and manage their FOIA requests and then make those materials publicly available so that people like me can collect them, preserve them, and give better access to them. 1 minute. So FOIA has been around for 50 years or so. Its application has meant increased openness and transparency and accountability, and it's been indispensable to the public's right to know what our governments do in our name. Though we've had some setbacks in certain administrations, I won't name names, but you can ask me later. FOIA improvement over time has frequently been due to considerable public advocacy from people like Ralph Nader, organizations like the Sunlight Foundation, and individual citizens. So 2 takeaways here. FOIA is a right, but it needs to be exercised and advocated for in order for it to be maintained and actually expanded on. And then the second, when you exercise that right to know, I hope that you'll do that next step of submitting your FOIA materials to some sort of a public archive like the Internet Archive so that they can be preserved and accessed for the long term. And with that, I'll pass it on to the next person. Thanks. Can you use this one or that one? Do you want to use my laptop or? Oh, okay, sorry. That's okay. Do you have slides? He's got them. Thanks, everyone.
We'll try to reboot, see if that helps.
Okay. Oh, I still had 18 seconds left. I could have squeezed in a little more.
I owe you.
Yeah, you owe me 18 seconds.
Okay. We're good.
Good afternoon, everybody. Is that a good volume? Can everybody hear me? I'll have to yell. You can't hear me? Okay. How's that? Is that better? Good. Okay, great. Good afternoon. My name is Trish Hines. I'm a deputy city attorney with the city of Oakland. I've been with the city of Oakland for about 6.5 years now. I do mainly advisory work. In my pre-Oakland life, I was a litigator, but I really don't do litigation that much anymore. My two main clients at the moment are the Ethics Commission and the Oakland Police Department, so I can definitely vouch for them getting the most public records requests out of the entire city departments. So what I'm here to talk about today is just a little bit about the interplay between the California Public Records Act, which is our state FOIA, and our local Sunshine Act, which is our local FOIA. And I'm going to talk about where they kind of intersect and where they differentiate. So this is sort of just a little roadmap of what we're going to be talking about. I'm going to first talk about the requirements under the CPRA, the California Public Records Act, briefly, and then I'm going to talk about the requirements under Local Sunshine Act, and then we're going to start comparing and contrasting. So, the California Public Records Act was enacted in 1968. It is modeled on our FOIA, the Federal Freedom of Information Act, but it's also part of our California Constitution now. It was made part of Article 1 through Proposition 59, which is a good thing. It applies to all non-exempt state and local agencies, of which the City of Oakland is one of them, and it was passed to ensure that the public has access to the public's information, the people's business. And it allows requesters to obtain all writings that are not expressly exempt. So just a couple of definitions so we all are on the same page. A public writing is basically any writing that contains information that's related to the public's business. And it specifically applies to those records that are prepared, owned, used, or retained by the government. And that's an important distinction because that means that if we have in our possession another agency's record or somebody else's record, just by the mere fact that it's in our possession, we are required to turn that over if it's not exempt. And writing is defined under the CPRA as broadly as possible. So it's meant to capture any kind of writing, photostatting, letters, audio, video on any kind of medium. And as it's been mentioned, there are various exemptions that agencies rely on to be able to withhold documents. And some of the more popular ones are for personnel reasons, for medical reasons. Law enforcement has a pretty large exemption they can rely on, as well as financial records. There's some exemptions there that we can withhold financial information. And then basically any privilege that exists in the state or the federal or in common law, we can rely on that to be able to withhold information as well. So now I'm going to jump to the Sunshine Ordinance, which is our local Public Information Act. This is found in Chapter 2.20 of the Oakland Municipal Code. Sorry, Albert. This was enacted in 1997, and it has been amended only once in 2003. It probably is due for another amendment soon. It also applies to all non-exempt state and local agencies. It applies to every department within the city. And it was passed to clarify and enhance, and in some cases go a little bit farther than the Public Records Act, which we're going to talk about in a second. One of the differences that's pretty apparent and immediate is that in addition to any kind of documents that you can request through the CPRA, under our local Sunshine Ordinance, you can also request oral information and expect to get that. In addition, the Sunshine Act provides for the immediate release of certain categories of documents, which we'll also talk about. So, in Section 2.20.200, each city department must designate a person most knowledgeable in order to facilitate both you obtaining your documents as well as oral information. So each department in the city should have a point person where you can go to if you're having trouble obtaining your documents or your information. In Section 2.20.210, this section requires every city department to maintain what's known as a correspondence file. So what this means is that any correspondence that is conducted on behalf of a local body, which we'll talk about that definition in a second, by a quorum of that local body, has to be maintained in chronological order. And so you should be able, as a member of the public, to go in to any department and request to be able to look at or copy the contents of this correspondence file. So when we're talking about local body, that's defined earlier in the Sunshine Ordinance, and it includes the City Council, the Board of Commissioners, and it includes all boards, commissions, task forces, and committees, which are either created by charter, motion, or resolution of the council or the board of the port, or created or appointed by the mayor, and that exist for more than 12 months. And what we mean by quorum is just a simple majority of that local body. So for example, the city council has 8 council members. A quorum of that would be 5 of them. So all correspondence sent and received by 5 or more of the council members must be maintained and be made available for public inspection. In Section 2.20.220, this is where you can find the list of documents that the city must release, and we cannot rely on the exemptions that are in the Public Records Act, even though they are there. So this list includes things like drafts and memoranda that are retained in the ordinary course of business, or they're retained pursuant to law or policy. It also includes litigation communications with adverse parties, but this only applies once the litigation has been fully and finally adjudicated. So that means a settlement or a judgment through either a jury or a judge. So once that triggering event happens, you should be able to see all of the communication and the correspondence between the city and that adverse party. In addition, we are required to turn over certain enumerated personnel information. Now, this is going to mainly have to do with kind of that overarching statistical, demographical type information. So like sex, gender, race, that kind of a thing. And it also includes any information that makes you suitable for your position. So that would include all of your training and education. All of that information must be released. In addition, there is certain law enforcement information that must be released also. And the way that the Sunshine Act goes a little bit farther than the Public Records Act here is that while we can still rely on a lot of the exemptions, what the Sunshine Act says is once the district attorney or the prosecuting authority has made the determination that there was not going to be a prosecution or the statute of limitations has run, then we must turn over that information. I don't know if any of you have experienced this in your FOIA or CPRA requests, but if you request something and you get a response back saying, no, sorry, it's exempt because of an ongoing investigation, that's usually where that matter would die. That would stop there under the CPRA. That's not the case under Sunshine. We have an ongoing duty that once the prosecutorial ability ends, that we would be able to turn over that information. In addition, other exemptions that we're not allowed to rely on, we have to produce contracts, which include bids, requests for proposals, and communications. However, we can withhold this while negotiations are ongoing, and that is because it's supposed to be for the benefit of the public. So in other words, we want the city to be in a very strong negotiating position while they're negotiating, and we don't want to disclose this information at that point. But once the negotiations have ended, you are privy to that information. You would be able to request that. And then finally, budgets and other financial documents. We have an obligation and duty under Sunshine to produce. So another place where Sunshine diverges and goes a little bit farther is in section 2.20.230, and this is the immediate disclosures section. So what this provides is that there's a list of documents which must go out the door immediately. And these three elements must be in place for this to occur. First, it has to be a document which was already previously produced. So things like the meeting agendas that we were talking about earlier. If that's already been published and produced, we must produce that immediately. And by immediately, the code provides that within 3 business days. That's what immediate means. There is an opportunity for the city to create a little bit of additional time for itself, and that is only if certain criteria within the act are met. So if we invoke that additional time is necessary clause, then we get an additional 2 weeks. And that's for things like if the documents are now stored off-site, or if code has to be written so we have to extract this data for some reason. So those are the types of things that would allow us to invoke this 14-day extension period. And then this is my last slide, just to give you a side-by-side comparison. You'll see the CPRA versus Sunshine. So CPRA was enacted in '68, Sunshine in '97. They both apply to all non-exempt state and local agencies. The CPRA was passed to ensure public access to documents, while Sunshine was passed in order to kind of clarify and in some cases go farther than the CPRA. And then finally, the CPRA applies exclusively to writings and documents that are expressly not exempt, while Sunshine goes a little bit farther. It applies to both documents and oral information. It provides for instances where we're not allowed to rely on exemptions in some cases, and it provides for the immediate disclosure of certain categories of documents. So thank you all very much. I hope that this was informative, and I appreciate your time.
Hello. My name is Reed Ducey-Gibbs. I'm one of the co-founders of Next Request, which is the software that Oakland uses to help manage their public record request process. My background is actually in architecture and design, and I started working on projects using technology to crowdsource information about urban development to make it more transparent to people. That sort of led me down this path. I became a Code for America Fellow way back in the day in 2013. After that, continued working in government technology, specifically starting Next Request, and I would describe myself as a pragmatic idealist. So a little bit about Next Request. We actually started in 2015. We work with over 100 local and state governments in the U.S. This includes Oakland, Los Angeles, San Francisco, Miami, Kansas City, many more. And we're a smallish company. We're 14 people, but we're growing. I think, as was mentioned before, I think everybody's probably fairly aware of what Next Request does, but it basically is a platform that governments implement, and it allows the public to make requests online. They're all tracked, and then it provides a bunch of tools for government staff to help manage and review responsive documents and, redact any private or sensitive information and then send it out to the public. And a lot of, the benefit is releasing those documents so that other people can look at them in the future, or they can see what other people have requested in the past as well. So I'm going to talk a little bit about some trends in FOIA that I've seen. I think I sort of have a unique perspective working with governments, understanding, a lot of the challenges they face. I've also made a number of record requests, so I understand that as well. And there's definitely it's a nice cognitive dissonance that you get seeing both sides of those. And I would say overall the process is just very difficult for everyone. And as was mentioned before, I think it's just generally unsustainable in terms of its overall trajectory. So have some thoughts about how to fix that. But I'm going to talk about just some general trends and issues that I have sort of come across in my work. So requests are increasing year over year. All of our customers that we talk to, they're pretty much always having their requests increase. This is true at the federal level. You can see every year, I forget who publishes it, but you can just see the trend line is just like this. And I think a big part of that is people are more used to digital services, being able to access information really easily, and that's what they expect out of governments. Governments generally lag behind in terms of adopting technology, and that lag makes things difficult. So, this was a number from the Sunlight Foundation, but it's just, there are a lot of requests being made. Another thing that I have noticed and was brought up a couple of times already is the commercial uses of FOIA. And there's actually a pretty good article, scholarly article called FOIA Inc., which I would recommend people read if they're curious about this specific topic. But it basically documents how all of these, for-profit corporations and, law firms, et cetera, are sort of using FOIA laws for that purpose instead of the primary purpose that it was intended, which is, transparency and good governance. I would say, the main reasons or the main ways that FOIA is distorted for these purposes is one around sort of competitive intelligence or just general information gathering. I lost a bid, I'm going to go request all of the information and records about my competitors. And, they basically just want everything and anything that the government has that might help improve their business. Another really common way that this happens is aggregation of data. So it's basically an arbitrage opportunity of it's really hard to make individual record requests, as a single person. So a company will go out and just make all of those requests, aggregate the data, package it up, and then resell it to somebody. And there are many, many, many cottage industries around this, whether it's government contracts, court cases and rulings, real estate records, et cetera. So basically, they're, governments and taxpayers are funding these companies' business models. And you might say, oh, well, they're ways that you can charge, but a lot of times it's like, I would charge like $1 for that, an individual request that a corporation might make. And a lot of times it's going to take like $5 in back office paperwork to like accept that check, cash it, record it, document it. It's much easier if I just send it out and, get on with my day and other job that I have in the government. So I think this is like a sub problem of the requests are increasing all the time. Another issue that is coming up more and more is the transparency versus privacy issue. And it's something that we see. We've had to do a lot of work around security and compliance and auditing, because even though we're dealing with public records, before those records become public and can be released, they could potentially contain private, personal records. And if governments want to use our system to review those documents, redact anything that is, like your social security number, they need to have it on our system. And we've had to do a lot of work around that. I think another sort of thing to keep in mind too is a lot of times government records and data are often our records and data. So a very specific instance of this that is in Oakland is when the city switched over from Record Track to Next Request. We allow governments to publish the name of the requester along with the request they made and how it was fulfilled, et cetera. There was a tremendous amount of pushback, even though that is a public record. Like if I wanted to go request the name of everybody that'd make a public record to Oakland, I could go do that and I could get that information. So I think that's just a really clear and small example, and even not even that specific in terms of exemptions. We also see things. A majority of requests at the city level are for police. And, there have been instances where police reports have been sent out with the name of a child domestic abuse victim. So, it's I'm all for transparency, but also the devil is in the details in terms of how things are implemented. I think that's more and more, if we want to do proactive release and allow people to just search records, there's going to be a tremendous amount of work in terms of sort of filtering what information should be accessible to everybody and what is, private personal data that should be withheld. The last thing I'll touch on is centralized versus decentralized systems for managing record requests. This is the model we see, or two sort of models we see a lot in governments. And basically, it's having somebody own the process within the city, even if different departments are responding to requests, versus just letting whatever departments do what they want. And generally, we recommend that cities use a centralized system, so having a specific person that is authorized by leadership to help manage this process. Otherwise, it becomes very difficult and ad hoc and a lot more inconsistent. That said, government bureaucracy is hard. It takes a lot of time, a lot of persistence, a lot of patience. I'd also say on this front, technology isn't going to solve everything. So, if you need to have good processes in conjunction with any technology that you're implementing, and at the end of the day, I would say, just to be sort of blunt, we are currently digitizing a manual process, which can get some efficiencies, but as was mentioned before, really how you solve this problem is to make information accessible online and do the work to have filters that automate what can go out and what can't in terms of public access. So yeah, I would just say, wrapping up, these are some of my favorite articles. I mentioned FOIA Inc. before, but Beyond Magic Markers was a good white paper that a nonprofit out of New York did. And also the Sunlight Foundation has a lot of good blog posts and original research around public record requests, as well as record requests and open data.
Okay.
So hi, everyone. My name is, I'll try this better. Good? Okay. Hi, my name is Jill Butler, and I am a commissioner with the Public Ethics Commission. The PEC is an independent entity which is charged with ensuring fairness, honesty, integrity, and openness in city government. I'm happy to be here to listen to any feedback that you all have about the Oakland Sunshine Ordinance. It is on our radar, so happy to be here. And thank you for the invitation, Open Oakland. So our commission has jurisdiction over 6 laws: the Government Ethics Act, which covers conflict of interest, gifts, and misuse of public funds; the Campaign Finance Reform Act, which sets contribution limits, voluntary expenditure ceilings, and e-filing of campaign statements. And I should note that this is not all-inclusive. There's others. I'm just giving the general over under every law. And the LPFA, which is the Limited Public Financing Act. This gives public financing to city council candidates. And the LRA, which is the Lobbyist Registration Act, which requires submission of lobbying reports. And the Sunshine Ordinance, which supplements state open meetings and public records laws. And the False Endorsement and Campaign Literature Act, which prohibits candidates from falsely stating that they've received endorsements that they have not. So we like to think that we take a holistic approach to accomplishing our mission. We lead or create legislative, administrative, or policy changes to ensure government integrity in systems, law, and policy. We educate city employees and the public regarding legal rules and regulations. We do outreach and engage the public regarding these legal rules and regulations, and we receive input via social media or perhaps meetings just like this. And we maintain public records and disclose these records upon request. And we enforce. So we do conduct investigations. We administratively prosecute violations of the laws that we are over. So our role in enforcing the Oakland Sunshine Ordinance, we have a duty to develop and maintain an administrative process for review and enforcement of the ordinance. When a public records request is denied or not responded to in a timely fashion, the requester may file a complaint with the PEC. It's important to note that they do need to go through a mediation process before formally filing the complaint. And it has to be with a representative from the agency and a mutually agreed upon mediator. And that can be, and usually is, a member of the PEC staff or just a mutually agreed upon mediator. So the mediation process is important because it provides parties an opportunity to discuss the reasons the PRR is delayed, denied in part, or otherwise deemed unsatisfactory. The mediation per law should take place within 10 days after it is requested, unless that's deemed impracticable. And the mediation may take place over phone as well. If the requester is unsatisfied with the results of the mediation, the requester may file a formal complaint with the PEC. After the complaint is filed, the PEC will start an investigation into the matter. If upon investigation the record is found to have existed and could have been but was not provided, the PEC can go to court and subpoena the records. So with most of the laws that we're over, we can impose monetary penalties and administratively prosecute these folks who violate our laws. However, the Oakland Sunshine Ordinance is different in that we cannot do that. We cannot impose monetary penalties or administratively prosecute those that violate this ordinance. What we can do, as I said earlier, is go to court and try to subpoena the records if we find that it does exist and should have been provided in full or provided. So next up, you guys may have heard in the last year the ticket policy coming up a lot with public officials receiving tickets to the Warriors and other interesting fun events. And so we are going to be reforming or trying to reform that ticket policy and the campaign finance policy as well. And just a reminder that although we cannot change the policies ourselves, like here today, we can review them, we can listen to input about them, we can hold hearings regarding them, and make recommendations or propose new policy or legislation. So that is it for me.
Well, let's take this opportunity to thank all of the tech didn't get too much in the way. Thank you all for staying on time. And now we won't, you can stay up here, but I'd like to ask the audience for any questions you might have. We're running a little behind schedule, but I think this is one of the best parts. Who might have a question?
Thank you, everyone, for your really informative and helpful. One question I have is, in the city of Oakland or your experience at other cities or counties, how do records retention schedules impact the long-term access to records and making records requests? I mean, it's sounding like with the systems that are being developed, the potential for just maintaining records kind of in perpetuity could actually be baked into the system. But what I've run into in other cities, Los Angeles in particular, is that they do expunge records after a certain amount of time. So I'm just curious, kind of specifically in Oakland, what type of records retention policies do you have? And then broadly, what is the thinking about that and how does that impact the work that you all do when you're managing those types of requests?
Do you have someone in particular you wanted to address it to? Or?
Anyone who wants to field that.
That's a great question. And in fact, San Francisco has an ordinance which requires every department to develop and publish publicly on their website a record retention schedule. Prominently, there are variable timeframes for some of the retention schedules. In some cases, it's in perpetuity. In some cases, it's years. In some cases, the last time I checked, for example, with correspondence, there's no retention period. Correspondence obviously includes emails, which is one of the major forms of records requests we get, since so much of written communication is in email form. I'm actually, there's not something like that in the city of Oakland. There are state retention guidelines, but I'm not aware of, and I think another person might be able to field the question about actually Oakland's retention requirements or the state minimums better than I. But yeah, like for example, in my office, we automatically try to preserve emails because they're of such public interest, and so we don't need to retain them, but we do because frequently we get requests, including going back some years. But in many cases, the records we preserve aren't required to be retained. I don't know if someone else wants to chime in.
Quick time up. Thank you, Tricia, who's left. We have other members of the city attorney's office in the House. Alex is the chief of staff in the city attorney's office and is willing to sit in her chair in absence. So thanks. Other questions?
Why don't I say something about that?
Okay.
So, State law requires that cities and counties keep records, two separate laws, for a minimum of 2 years. Other records have longer retention periods, some quite long. But state law requires that before any record is destroyed, putting aside records where there's a copy that's been made, they need local legislative authorization for cities and counties. So my reading of that law is that unless the City Council or County Board of Supervisors has passed a law that allows the destruction of any type of record, they should not be destroying any records without keeping copies. And at a minimum, they have to keep them for 2 years. Some records have considerably longer retention policies. Oakland's retention policy, you can get it on the website because people have requested it and they have provided it. And it does have very long records retention policies for some places. Other cities do destroy their records very quickly, kind of as soon as they're allowed to. It's a problem. I don't know why they have to do that now when it's so cheap to store them, but it's not illegal. It's just maybe bad policy.
Yes. So let me say again, we have on openoakland.org a tab that says resources. There's currently a page there that's captured a lot of the resources that have been mentioned here. We'll add to that list, and in particular, we're going to add all these slides to that list, and as we get the audio and video recorded, links to them would be available there as well. Did you have a question? Yes. Okay. Well, Mike, you want to see if you can run it to him? Thank you.
Oh, I'll just stand. So my first question is, what is the reason for having the possibility of deleting records from the system? As I know it, storage is relatively cheap these days. Is there anything that I'm not aware of that makes it so that there even is a deletion policy for records? And my second question is, in the city of Oakland, how is the data currently getting stored? What is the structure of that data? I noticed that we said how difficult it was to give this data on request because it requires processing on the city side. I was wondering what kind of improvements are being done on that end. Yeah.
Do you want to address it to someone in particular?
Anyone.
Okay. Someone have Alex, you
Hi. I think the first question was, what is the reason for retention policies that allow agencies to delete record or destroy records after a certain amount of time? And I don't know the answer to that, but I did want to say that some of the laws that we're dealing with were written before the internet existed. So they sort of treat all electronic records the same as they used to treat boxes of paper records. And we kind of run into that issue a lot when we're dealing with records requests. So that I don't know the reason for why retention schedules exist to allow the destruction of records, but really, when we deal with records requests, almost all of the requests that we get are for email records or for electronic records, but most of them have to do with email. And so for the city of Oakland, we have, those are basically kept, and at this point they're kept indefinitely. Different departments might try to scrub them according to the retention schedule, but most of the time when we're looking for email records or electronic records that go back even years, we're still able to find them. And in the city attorney's office, we actually have our own servers, and so we keep everything forever. And your second question was, can you repeat it again? Yeah. The biggest challenge, I think, for the city of Oakland, and I'm sort of speaking for all of the city, although I really can't do that, but just from what I am observing, is our staffing. All of these requests take, some amount of staff time, and some of them take, some of them are complex, so they take a lot of time, and we just have that's a big challenge for any type of request, because we have so few people that are available to work on these requests, and even the people who are assigned to do it, that's usually just one very small part of their overall job. So it's just a question of our resources. That's our biggest challenge.
And just to add on to that, at the federal level, agencies are still working under statutes that are, written 50, 60 years ago. And so, for example, there are some agencies who still submit email records to the National Archives in paper. So they print out emails and send them to the National Archives. The National Archives has written recommendations and gotten a change in the law so that by 2022, anything that's created electronically will be submitted to NARA electronically, but it's still very slow. And agencies tend to go by the letter of the law, and that's why a lot of things are scheduled and then destroyed after a certain amount of time. It's unfortunate, but I think with discussions about like proactive release and digital records being preserved digitally, I think that will change slowly but surely. But it's going to take, I think, public input and public pressure on government agencies at the federal and state and local level as well to change those laws so that those things don't happen.
So I think the primary reason is because we have these laws that were written before data storage was so cheap. There are also constituencies that want government records to be destroyed as quickly as possible. The one that comes to mind is in California, you have to keep peace officer personnel records for 5 years, and there are cities that keep them a very long time. Oakland does because it has a citizen review process. In other cities, the police have gotten a local law passed that says 5 years and a day, those records are destroyed. And they do not want those records kept around because they don't want people to know about it. And that's the one example. There are other examples of constituencies that want to use destruction schedules to hide information from the public. And I think that that's something people need to advocate against.
Let me ask one question, and I'll direct it to Oliver, but maybe the rest of you have responses as well. And that has to do with, suppose we were trying to imagine what we would want a newer Sunshine Ordinance to look like. Could you shepherd us through from political will through that process, and what would an amendment that recognizes the 21st century look like in Oakland if we tried to push that through?
Well, I think an amendment to and Trish kind of alluded to this, an amendment to the Oakland Sunshine Ordinance is coming. And there's various types of improvements and reforms that can be done to it. I don't think that's going to address the problem of 21st century data collection and how records requests are effectively archaic. I don't think that's going to happen. I think it's just going to preserve what we currently have and try to make improvements to it, because I think proactive disclosure isn't going to, it's unlikely that a single city is going to take that on alone just due to the sheer cost of it. And I would rather the state get, frankly, take the lead on that than an individual city due to the cost. But in terms of types of improvements, and there's a variety of things. This is something that Councilmember Kolb has been interested in doing and working with the Public Ethics Commission on. For example, one of the big things that I think a lot of requesters might agree with is that there's a lack of City of Oakland enforcement power. Basically, your enforcement remedies are requesting mediation or threatening to sue, neither of which is good for really anybody. The mediation can sometimes be good, but it doesn't have teeth. And the lawsuit is a very blunt instrument that the city obviously does not want to encourage. So a local enforcement mechanism, such as through the Public Ethics Commission, would be something that that we would be interested in thinking about. But there's a variety of other kinds of things besides that. Being more clear about the retention schedule, I think, would be another one.
Anyone else want to talk about future stuff? All right, let's let Remy have the last question.
Hi, so my name is Ramy. I am an Oakland constituent, and one of the things that I think about a lot is ShotSpotter. I think about it all the time, from a privacy issue and also from the fact that it's a black box. And so I was wondering if anyone on the panel could address sort of like, so from my perspective, for full disclosure, I'm part of Open Oakland as well. If I wanted to somehow audit the efficacy of ShotSpotter, how would I go about doing it? Granted that it is a proprietary algorithm that they use, I feel like I have like no way to like make it through the cracks to get access to those data. And then meanwhile, on the ShotSpotter side, it makes it seem like over the course of like 5 years, gun violence has gone down 71%, which is bunk, right? So, right, I'm trying as best as I can to get some sort of information as to how we could audit that.
It sounds like a proto PRR request.
I think also, sorry, in the aspect of amendments to future ordinances, the question of will we ever get to a point where we can actually say, when it deals with public safety, that we can actually access those records for auditing? Or is there any direction?
So, for example, James, you mentioned that FOIA does not include government contractors' information. ShotSpotter is a contractor with the City of Oakland. Can anyone speak with authority as to what, if any, constraints are on information provided by that contractor?
You know who could have answered this question is Trish.
I'll text her.
Huh? Oh, well, without giving any legal advice, she might have had some perspective on it. I guess it might. What type of information would you be looking to audit? Just how often the system is activated and how the police use that?
Right. One example would be, so ShotSpotter said that they, were able to triangulate that information and were able to see like single gunshots within a specific perimeter, like 73 of them. We don't know how to actually verify that because the way the police reporting is done and then sort of like the real-time triangulation, whatever it is, we don't know how that actually happens. So when you're correlating gun violence with ShotSpotter, you can't actually make those correlations. But from the marketing perspective, they do. So you can't compare apples to apples. And so meanwhile, cities are spending millions of dollars in Oakland, one of them. There's really virtually no way to know. And we don't know what data they're actually collecting.
Right. I don't know the answers to those, but that is a very good question. I think, and we also can't defend that contractor, the company, We can't speak for them, but I can tell you over the years, I've heard from the police department that they like that tool and that they feel like it's helped them solve crimes. I know there was at least one homicide they've solved because of something that was recorded on the ShotSpotter device, according to OPD. So I'm just telling you what I've heard, sort of anecdotally. Okay.
And I think in the long term, the city could do sort of what South Africa did with their FOIA law. They wrote private contractors into the law because so much of South Africa's government working is done by subcontractors and not by government agencies. And so they made the FOIA law cover those subcontractors. I think Oakland could probably do the same thing, where they say if there's a private institution that is contracting with the government for government services, that there should be some sort of way that it either falls under Sunshine or that data that's created by those systems is able to be publicly audited. I think that would be a really good way to do it.
Since we're talking about ShotSpotter, I'll mention a factoid. One of the first times I was in a conversation with ShotSpotter folks, the fact that the correlation between gunfire and calling 911 is bimodal. There are communities where as soon as a shot is fired, 911 calls rain in. And there are communities when shots are fired, they know about it, no one calls. If there is an indicator of tough parts of the city and parts of the city where people feel safer, that's a pretty amazing indicator to me. That would be a kind of correlation I'd be particularly interested in. Michael, you wanted to say something too?
Stop remembering that. Sure, just briefly. Under the California Public Records Act, if the government is using data and it has a contractual right to access that data that's in the hands of a private contractor, it should be a public record, and it should be available under the Public Records Act against the government entity that has a contractual right to that data. Law isn't entirely clear there, but it's clear enough that you should go ahead and request the data if you ask for it. As I said earlier, if you're interested in the information, there's no harm in requesting it. The worst that happens is they say no. I don't know exactly what the relationship is and what the data, but as a general principle, you may be able to get it.
I think I'm going to call that an end of our question period. Let's thank them one more time for a terrifically informative afternoon. So now, please stand up, take a biology break if necessary. We have snacks over here. The general idea then is that we, first of all, meet one another. If you see someone with an Open Oakland tag, and some of my friends from there don't have their tags on, but they'll introduce themselves, ask about Open Oakland, come to a meeting. And then, the ShotSpotter example, or how many of you have an idea about a PRR you'd like to make progress on here? Colin does. John does. Okay, so let's use you as seeds of little groups to just spend some time talking about that, trying to sharpen them up, and then some of us will try and respond to those. We'll get back together in 15 minutes to break up into little groups. Okay, who would like to kick off describing a PRR they would like to write? Okay.
Mine is a very nascent idea. It's not specifically local to Oakland, but in the county of Sonoma, there's a publicly viewable map with a shape layer on it of the shape layer predicts flooding in West Sonoma County, which is topical right now. And so my friend who lives in the county of Sonoma, he wants that shape layer. He just wants that data, the GeoJSON or whatever it is. Apparently he's had some resistance. There's like politics involved, maybe.
John, where's John? John's been my image as we put this event together.
Hi, I have a public data request out actually for Oakland Unified School District's budget data and also staffing data. I've already submitted this, so maybe I should be last in line in terms of support. But if anyone is interested in that kind of data, like education data, I would say, or anyone wants to give feedback on the request that I wrote, I'd be very interested in that.
Great. Anybody else?
I'm mostly just spitballing, but I have an interest in the communications that happen between homeless individuals in Oakland and city officials, because sometimes we don't really get enough of the story of what's happening. So if anybody is interested in figuring out how to find more records on that, that would be of interest to me. Thanks.
Great. Let me just also say, Leah is our host here in this facility. We wouldn't be here without her, and East Bay for everyone. Okay, so we have, I'll say 4. I'm happy to talk about, Ramey. Where's Ramey? If you want to think more about the ShotSpotter thing, I'd be happy to have that be 1, 2. Okay, so let's do that. We'll have ShotSpotter, education, budget, and staffing. Sonoma County map. Was that it? Okay, so, oh yeah, and Leah, the communication with homeless in Oakland. So that's 4. Colin's kind of over there. Leah and Raymond and I will kind of hang out here. John's situated there. So self-organize yourselves into one of those groups, and let's just kick that around for a little bit. And if you can transcribe just a short version of it, then we'll be able to, and send it to me as an email or something. Then we can all look at one another's. Okay, so let's do that for just like 15 minutes, and then we'll get back here and wrap it up. Oh, great. Okay.
So please feel free to ask me any questions to clarify what I'm saying, because it might be all over the place. But we're trying to come up with strategies for identifying some hidden homelessness issues in Oakland, or not necessarily hidden, but they're common knowledge, anecdotal, but they don't have adequate statistics. It was suggested the HMIS system for Alameda is a homeless client tracking system, which may contain partial data about the homelessness population and the interactions that different agencies make with the homeless. And then we sort of narrowed it down to the elderly and disabled and what kind of information we can search on them. One idea is how many elderly disabled people are homeless due to medical bankruptcy, or elder abuse, or are getting increase of rent or evictions. And then there's also looking at organizations that deal with, for instance, blind people, because blind people are in a sort of gap with their aid, where they can't receive certain types of federal or state aid, but they're still a vulnerable population. And then also we were looking into shelter information because there was this interesting story that came out that there was a San Francisco shelter that has like multiple beds that people can sleep in at night, but people don't stay at the shelter. They just show up, receive services, and they leave the shelter. So it would be interesting to do a public information request as to why they didn't stay at the shelter overnight, but they still opted to get those services and how effective the services were. So, yeah.
Any reactions? I hear multiple agencies going after information from multiple agencies. That sounds...
Oh yeah, there's also Medicaid and Medicare information requests for the medical bankruptcy statistics. So.
Doesn't Muck Rock have a facility that supports that? Seems to me I've seen it there.
At the federal level, yeah, but I don't know at the local.
Uh-huh. Yeah, and across jurisdictions, that's a great question. Muck Rock does provide sort of the infrastructure to keep these things alive and check whether they've exceeded a timeline and things like that for particular files and stuff like that. So it's conceivable that the same system could route to two different agencies the same request or something. I don't know though.
I mean, legally, you can send a request to a county, you can send a request to a city, you can send a request to some school district, and they're required to give you all the records in the possession of that city or county. When you talk about state agencies, we do have to send it to the individual agency, the same thing with federal agencies.
And one of the things that came up, Alex is left now, I think. He said that, when you file using Next Request, you specify the agency, the department that is to handle the request. But you don't have to specify that. And if you don't, then it's his office's job to decide which department is the one to get that request. I also asked him how many come in over the desk as opposed to over Next Request. And he said very few. It's an exception to the general pattern, which is that they use this facility. Okay. Sonoma County.
Hi. So I found this form on the Sonoma County website, which is nice of them to provide a form. It's very open-ended, and I had a lot of questions about how technical versus specific I could or could not be, because as Thomas pointed out or questioned, who is going to be tasked with fulfilling this request? I want, like, GeoJSON data would be ideal, and I assume that ArcGIS can export GeoJSON data, but what if it's an office admin who's tasked with fulfilling this request? I just don't know how that would work on their end. So the first thing on the form that I was sort of struggling with is it says address or file name. So I have a web address for the map, and I also have a layer, the name of the layer that is viewable on that map. All that doesn't fit in that field, so I broke it up. But I put the layer name and the link to the map, and I just said I am requesting the shape layer as GeoJSON, XML, or whatever format your software exports of the flood zone along the Russian River in West Sonoma County. I was also wondering, I don't want an ArcGIS proprietary file, because that would not work for me. So should I specifically request GeoJSON? That would be the easiest format for me to digest. Or KML, yeah, totally.
But in an open, non-proprietary.
Exactly.
Well, it depends. I mean, it always depends. Some are using it so they can export into GIS or a KML file. But it seems like asking for it in a non-shape.shp file would be ideal. But I can see what they make me back and say that's too much for us. But again, if they use Studio federal level, they should be able to export that.
So then another question I had along those lines was, do I need to know the department? Because I have some inside knowledge that this map takes input from several different departments.
I would go to the GIS department, the one who's actually, which website is he sitting on?
I think it's sonomamaps.arcgis.gov.
They've collected it, consolidated it, and put it out.
Okay.
This is a request to the County of Sonoma.
Yeah.
So there's a tension that the Public Records Act on one hand doesn't require them to create a new record, but it does say that the requester has to pay for data extraction or some other program, which clearly contemplates that they'll have to do some sort of conversion.
Yeah.
And so I think that you should say, I want it in any of these formats, or just the one format you want it in. If that's a problem, and I mean, you might say you're willing to pay for the conversion, if you are. If not, I just would mention that. And under the state law, they have a duty to call you up and help you figure out how to get the data. And so I'd say, please, the Public Records Act requires you to help me out. Please contact me so we can figure out exactly how to.
You think I should specifically call out the Public Records Act in my info box here?
Sure.
Okay.
I mean, you don't have to, but
It's a good idea.
If you look through a lot of them in Next Request, for example, they all begin with a very under the California as
Okay.
added by, so, flowery language.
Okay.
This also seems like a great example of where the 21st century notion of a document doesn't fit whatsoever. There is no document produced to be asked for. This is a dynamic website that's throwing up maps as you zoom around. So, the need to do a software query to retrieve what you're looking for is going to be true of all of that stuff.
Well, now that you start to say that, it occurs to me that certainly the ArcGIS developer interface can export something at a click with me, but there's probably some Python that is generating this layer because the layer itself is dynamic. It's showing the current flooding now. So then can I request the Python? Can I request the script? I don't know. Yeah. Okay.
Let's take a minute to talk about the ShotSpotter request, and then we'll use our last remaining, and we're going to get out of here at 4, except for those of us cleaning up, because I promised I would do that. So, Ring.
So those of you who have already heard, the whole ShotSpotter thing was basically to figure out how we can get more information about how these algorithms are being used. So it is ultimately at its root a data and privacy issue, but we thought about, practically speaking, how we could actually request data related to ShotSpotter. So imagine I am just a person on the street well, this is a true story. So there was a shooting right in front of my house, January 19th. And so we can start there, and we can actually ask for data specific to that particular incident. So instead of broadly asking, what are all the data you can provide me? Because actually, if you go to Oakland's website, you can get aggregate data from OPD about ShotSpotter, but it doesn't tell you like incident levels. So if we can start with one incident and then ask what kind of data are associated with that particular shooting, the type of shooting, did police respond? I know that answer. Police did respond. And then kind of see how the ShotSpotter was used in that particular incident. We can at least deduce some things about how it's used on a practical level. From there, I don't know where to go from there. I'm hoping that they would release that information and I can have some idea of how ShotSpotter played into that particular incident. And then the larger issue is at that point, what data are missing, what data are needed to do sort of like a third-party audit or a public audit of the efficacy. So I think it's good.
That's a great example. I mean, it's personal. It sounds like two public requests to me. One for this sort of incident level, everything underlying their aggregate statistics, and one drilling down on a particular incident. Sounds like great. Do you have an incident number associated with it by chance?
No, I don't.
So we can use OhCrime to find that. Okay. All right. Well, we've done a lot. What are you coming away with?
Oh, no. He's saying to use the mic.
Again, a lot of the details on those slides are things I'm going to go back and plow through. They'll be up momentarily. But what takeaways do you have? What are next steps? I'm open to any final summary responses. John.
One takeaway for me is to not be shy with your requests that Michael mentioned. Ask for what you want. The first thing that happens is
Yeah. You know, something else that Mike can speak to, one of the things I heard was, you know, so we go through this process, making a request, takes a while for them to reply, maybe they say they blow us off. There's a mediation process that we need to understand better in terms of going through PEC to mediate that request. Let's say they continue to blow us off. Then we need an attorney to sue. And one of the things that I have heard from now 2 attorneys is they love these cases because the law behind, take it from there.
A lot of cases I fought in my career at the public defender's office, defending people and at the ACLU were not particularly popular among judges. Judges like public record suits because the public likes the Public Records Act. And the law is good. And if you win a Public Records Act suit, you get your attorney's fees, which means that lawyers who specialize in these types of cases can bring them without charging. Some of them I didn't. A lot of my cases, if I see an interesting case, and I think it's possibly going to win, and I got the time, yeah, bring it. And there are other lawyers around. Abenicio works on that same level. Try to work things out with the government, try to mediation, but if in the end you really don't think that they're giving you what you're entitled to, consider bringing a lawsuit.
That sounds like a conclusion to me. Thank you all very much. This has been a great day. Come by Tuesdays at City Hall. Thank you.